Public identification of these individuals could subject them or their families to retaliatory violence or persecution. Look, okay, their families might be harmed by you. The judge is presuming that you're a criminal. So like all of these cases are distinguishable. They're all really terrible cases, which is why this judge is such a terrible judge who should be removed. Every day, like broken records, where are the Republicans saying Judge Boasberg is in violation of the Supreme Court? He has no jurisdiction at all. He's ordering this stuff to happen. He should be impeached. Judge Boasberg does even more of the unthinkable. Now, in addition to demanding that Trump return all of the deported alien enemies back into our country, bring them on back, he said, now he's going to conceal their identities so we don't even know who they are. And they can proceed throughout their litigation in a pseudo-anonymous fashion, because the last thing they want us to do is know who they are. If we know who they are, then we can investigate them and discover things about the Maryland man, like Kilmar. They told us he was like this innocent person who did nothing wrong, was just here to improve his life and be a good father. Turns out he was beating his wife and trafficking illegals into our country. The more we know about them, the more names and identities we can get, then the worse it is for them. So the hack judges who are now circumventing the executive branch and have been doing it for months now are providing illegals with more benefits than you get. This is from Judge Boasberg, Washington, D.C., the same judge who the Supreme Court said, you don't have any jurisdiction over these claims because they should be brought in habeas in Texas. He wrote 2 orders. This is the first one that's irritating. He says, look, first, we're going to talk about habeas petitions. And in fact, we'll come back to that. Let's start with the pseudonyms that he allows. Most of the petitioners and their next friends now seek to proceed pseudo-anonymously, right? These are a group of people who are individually detained in criminal custody in many locations, saying this court is going to grant the motion so they can proceed. It's basically anonymous, subject to further consideration by the U.S. judge who's assigned randomly to this case, which of course he was not assigned randomly. He says, look, now generally a complaint must identify the plaintiffs, right? These are the rules that apply to all of us, you and me. We don't get these special benefits because we're just citizens who follow the law. If you want to get a benefit, you should be an illegal alien breaking the law and then call the FBI and they'll let you go. This identification requirement that you identify who is actually suing reflects the presumption in favor of disclosure of the litigants' identities, right? The judge is going to give us all the rules before he throws them into the shredder, which stems from a general public interest in the openness of governmental process, right? That's what we want. And the tradition of open judicial proceedings. These are American traditions that they are throwing by the wayside. Now, a party moving to proceed pseudo-anonymously, like these people are, bears the weighty burden of both demonstrating a concrete need for the secrecy and identifying the consequences that would likely befall if you could just use your own names like Kilmar did. As a result, the court must balance the litigant's legitimate interest in anonymity against countervailing interest in full disclosure. A little bit of a balancing test there. Well, why do you need it? Why don't you want it out? Apply a flexible, fact-driven balancing test. All right, so this judge is going to now balance the terrorist right to privacy, the alien enemy's right to privacy, with our public right and American interests in knowing who these people are who are challenging the president's order of removal by delineating them alien enemies against the will of the American people. The judge says, here's what I'm going to consider. It says, I'm going to consider whether the justification asserted by the gangbangers, terrorists, is merely to avoid the annoyance and criticism that may attend the litigation or is to preserve privacy in a matter, right? Is it only just because you're like scared? What's up? Whether identification, we're balancing these factors, poses a risk of retaliatory physical harm to the gangbangers or even more critically to innocent people. The ages of the persons, are they young? Are they old? Are they like 8 years old? Are these like 40-year-old dudes? Whether the action is against the governmental or private party, and relatedly, the risk of unfairness to the opposing party. Okay, so you can just weigh those factors and we win every time. 5 out of 5 on all of those. Whether the justification asserted by the requesting party, yeah, they don't want to be criticized because they learned they tried to hoax us with Kilmar and they said the Maryland man, the Maryland man, the Maryland man, many times over to try to beat it into people's brains. He wasn't a Maryland man at all, wasn't a citizen, was in the country illegally, had 2 orders of protections where he was beating his wife and threatening her kids and maybe his kid, causing what some people might say would be reckless endangerment, multiple felonies, skidding around in the car with kids around. The whole thing was egregious. That was just his domestic relationship. Then there's evidence that the Tennessee police stopped him, wanted to investigate him, called the FBI to bring them down and do it. Didn't do it. He had 8, 9 people in the back of his car. Many of them all of them had no luggage, no real basis for them being construction workers, questions about whether they were men or women being trafficked to go do construction somewhere. And the list goes on, right? Then he's got the MS-13 tats. He has been seen and arrested with gangbang gangbangers in a parking lot. He was adjudicated in a court of law, had an appeal process on that, and then adjudicated for withholding. And all that time, they tried to cover every bit of that up. And that withholding, by the way, was essentially fictional based on the judge's order from David A. Jones, which we've talked about before. So all of those things, if we would have known about it, right, that hoax wouldn't have caught wind. So they need to bait and switch people. They don't want you to switch. They want to bait you and hook you on this idea that they're Maryland man. But this is obviously not. So if you can go through these, right, whether the justification is to avoid criticism and privacy, he'll walk us through them. He says, at this early stage, they have succeeded in showing, okay, so the illegals, people just like Kilmar, who had the same process, same adjudication, more or less, right, not all identical, because every case is an individual basis. Not all of them are beating their spouses like he was, but petitioners have succeeded in showing that their privacy and safety concerns, okay, so the gangbanger alien enemies who've been identified by our government, who deserves the presumption, the benefit of the doubt, outweigh our presumptive and substantial interest in learning their identities, okay? So because people could be mean to them, like we are to Kilmar, because we don't like illegals in our country beating our citizens, then our own FBI letting them run free, we're pretty sick and tired of that. So we don't really think that they do have privacy rights. They're criminals in the country. And the safety concerns outweigh the public's right and substantial interest in their identities. This is a judge who just gave illegal terrorist aliens more rights and privileges than American citizens. There's a presumption that we get to know their names. That's the default rule. He overrode it. He admitted. He wrote it right there. Now, the first factor supports the granting of the motion. He says they don't seek to proceed under pseudonyms merely to avoid the annoyance and criticism. Yeah, right. He says, for instance, they allege that it contains details of their asylum claims, like the abuse and the danger they faced in Venezuela at the hands of the political leaders or paramilitary groups. Okay, that's in Venezuela. Now, that information is confidential, as they note. Federal immigration regulations say, oh, okay, so I got it. As long as they apply for asylum, part of the record when they file is confidential. And so therefore, what can happen now is they can proceed pseudo-anonymously because he's conflating two different things, right? This is not an asylum case, but because in their asylum case, they made some ridiculous claims like they all do about pupusas, attack, gay, whatever. It's all made up nonsense. And we don't care anyways, by the way. That's their problem in their own countries. They can deal with it down there. Now, the second factor tips the same way. As petitioners and their next friends clearly seek to avoid retaliatory physical or mental harm. You think you could do this for any of the J6ers, for example? Like, why didn't the J6ers get allowed to proceed pseudo-anonymously? How come they didn't do that? Yeah. Given the claims in the asylum applications, public identification of these individuals could subject them or their families to retaliatory violence or persecution. Look, okay, their families might be harmed by you. The judge is presuming that you're a criminal, that all of Americans are just going to be so violent and mad that they're protecting these gangbangers that they can proceed anonymously. But no one else gets that privilege. No one else gets to do that, to claim, I have a presumption of innocence in America, okay? Until you present some more evidence, I don't want my mugshot posted anywhere. I don't want my names posted anywhere until I'm convicted. Do you get that right? Of course you don't. Now, as Homeland recognizes, the confidentiality regulations are of utmost importance in protecting blah, blah, blah. So he goes and cherry picks some stuff that he can see. In other parts of immigration, we can do things confidentially. So petitioners do not address the third factor, the age, because they're all old dudes probably. So the court will assume that it weighs against pseudo-anonymity, saying there is in any event no indication that they're minors. Okay, so they don't win that one. The fourth factor, so the second factor he also gives them, right? So retaliatory violence, and it's got some precedent in other immigration components. The fourth factor weighs against anonymity as well. It says typically anonymous litigation is more acceptable when the defendant is a governmental body because they don't share the concerns about reputation and more. And here, the factor tips in favor of disclosure. Okay, so he's like giving us the four factors. Two in favor of an anonymity. One kind of against anonymity. This one in favor of disclosure. So we've got like two over here, one kind of in the middle. And fifth and finally, they say the government would suffer no risk of unfairness. So there you go. First, second, and fifth weigh in favor. Terrorist gangbangers can now proceed anonymously. See if you'd like to proceed anonymously anytime that you're accused of a crime. And by the way, you have the presumption of innocence that attaches to that. And you're an American citizen. Say that you don't want your name showing up on any arrest records or any arrest logs anywhere when you're being processed by the government at all. Even a civil claim. Say you don't want your name in an order of protection. Say, you know what, I don't want my name in my divorce records, right? You got to fight for that. So this judge grants all these terrorists anonymity, says fifth and finally, no risk of harm because it doesn't matter to us. The factor does not require such disclosure because the government's not going to be harmed if we don't know his ID or any of these people's IDs. So that's That tally is in favor of the gangbangers, says Judge Boasberg and his abortion-loving wife and his, I presume, illegal aligned daughter, right, who are all in this industry and this grift, accords with the court's prior grant of allowing them to proceed anonymously. So the court now says you can file under pseudonym. It is granted. So we can't know who these are, because if we know who they are, we'll identify a bunch more wife-beating Kilmars, and they don't want that. All parties shall use pseudonyms listed in the complaint in all documents, and within 14 days, petitioners and their next friends must file a sealed declaration containing their real names and residential addresses. So we don't even know if they're real people at this point. Judge is like, well, what are their real names? And where do they live? What a joke, okay? Are they even actual people? How do you know? We can't know. The judge will know. The DOJ can't talk about it, right? The DOJ can't leak any of these things. So we have a bunch of anonymous class action illegal alien terrorists who can just run roughshod over the entire system. Thanks to Judge Boasberg, one of the worst judges in Washington, D.C., who should be impeached immediately for allowing this perversion of our justice to occur. Now, he also wrote this one. He says, I'm also going to allow some discovery to happen here in this case. Says, now arrives the latest installment. He says, this is a complex and fast-moving lawsuit because you're making it move fast, challenging Trump's invocation of the Alien Enemies Act. And what's interesting is he's using their full names here in this order. He says, Frangel Reyes Montoya and Andre Jose Hernandez Romero and 4 other Venezuelan men, maybe they're self-identifying, or are those their pseudonyms, were transferred by Trump to a CCOT. Now, claiming they are held there at the behest of the United States, they now seek to file their habeas claims for themselves and a class of other Venezuelan deportee gangbangers, right? So habeas, by the way, should be filed in their petition of detention. They're in detention in CCOT, so there's a good argument that they can't file habeas claims since they're already afuera, right? They should have done that before. So now they're trying to reverse this. And there's a bunch of terrorism claims on this too, right? Back from the terrorist cases. Like, can you file a habeas claim if we've sent you to some foreign detention site? Like, we don't really have control over you. You're not in America anymore. So can you really file that? The necessary threshold question is whether they are in custody. This is going to be the big battle here over constructive custody. Does Trump control CCOT even though he doesn't control CCOT? The court believes discovery could aid in our analysis, just like over in Judge Zenas rhymes with. Now, the federal habeas statute extends to others any prisoner who is, quote, in custody, right? That's the argument. Well, Bush was saying, oh, they're not kind of really in custody in Guantanamo. It's kind of a foreign site and, it's not really in custody of us. Or under by color of authority of the United States, right? So Trump did this one further and said, okay, not Gitmo. We're just going to send them to CCOT. Like, we have no color of authority over that. Saying, while custody is thus central to jurisdiction, as the Supreme Court said, which is why this is hilarious that this judge is even writing this, because the Supreme Court said, you have no jurisdiction, judge. Should be brought in Texas. Courts have, in keeping with the broad statutory language, have very liberally construed that. Yeah, no kidding. Saying here, in particular, it has long been true that the use of habeas has not been restricted to situations where there's actual physical custody. The Supreme Court, let's see, has, for instance, found habeas jurisdiction where a petitioner is free on parole, but remains subject to restraints imposed by officials, like when they're awaiting trial. Like, you've got control over the person because they're on an ankle monitor, okay? That's not what we're talking about. In America, like you're on an ankle monitor in America. And that was looks like a Boston case. Now, courts have also recognized that habeas lies where a petitioner is imprisoned by a private party, but that is at the behest of the U.S. government, which is an 1888 case, okay, when somebody was the captain of a steamship. So government arrests him, captain of the steamship says, I'll throw you in the brig. Guy sues, said he threw me in the brig. I bring a habeas petition, let me out of the brig. Government said, no, we don't have control of him. The steamship captain does. Government says, well, you do. He's holding him for you in America under American law. Now, so again, here's another one. Same one with the private prison, right? Same thing there. Like, the government can't hand you off to a private prison in the United States after you've been convicted of a United States law and then say, we're not in control of you because Walmart Prisons R Us is in control of you. Was imprisoned in one jurisdiction, another. And finally, like, none of these are on point. Thank you for this terrible references list, Judge. And most relevant for present purposes, one court in this district has held that federal habeas was possible, indeed likely, here you go, where a U.S. citizen was held abroad in a Saudi Arabian prison at the behest of U.S. authorities. That looks like that was a Bush case, right? 2004. But the organization principle for such disparate situations, writes Judge Boasberg, is the concept of constructive custody, right? Because Trump doesn't have any, like, physical control over CCOT, obviously, right? He's got no real contractual control as far as we know. But does he have some other type of levers that he can use, knobs he can twist in order to to get stuff done down there. Now, according to one leading formulation, writes Boasberg, constructive custody exists where the imprisoning sovereign, in this case Bukele, is the agent of the respondent, right? Is Bukele an agent of Trump? The prisoner's liberty is restrained by the parole conditions, or the prisoner can point to some continuing collateral disability, which is the result of the respondent's actions. Now, in another case, the Supreme Court explained that the state holding the prisoner in immediate confinement acts as agent for a state with a detainer against that individual, such that the prisoner can bring a habeas action in the latter jurisdiction. Yeah, but I think the situation here is that the United States does not have a detainer on the person, right? Kilmar's gone. Like, we don't want him. We don't have a detainer on him. In the Saudi Arabia case, that was a U.S. citizen that we wanted in custody, right? That was actually a U.S. citizen in that case. So, like, all of these cases are distinguishable. They're all really terrible cases, which is why this judge is such a terrible judge who should be removed. Everyone you can distinguish. You say, okay, he was free on parole. Okay, so is this U.S. citizen? Great. And he was restrained by U.S. officials. This other person was the steamboat ship. Great. Another U.S. citizen obtained on behalf of the U.S. government by somebody in the United States. Okay, great. All of it's distinguishable. This one, a U.S. citizen. Great. All of these people are not citizens. First of all, that's the biggest distinction. And number two, the U.S. citizen was being held. Saudi Arabia was acting as an agent, right? If you want to go that far, to say they were holding him on behalf of the United States because we're going to deal with him in turn. But that's not what's happening here. We wanted Kilmar gone. We don't want anything to do with him ever again. He's not coming back into this country ever again. Now, as a result here, right, CCOT is not an agent and there is no ongoing detainer. So why would he be able to bring a habeas action? It's all done. As a result, when a respondent works through an intermediary, they can bring a petition against the respondent. So they're allowed, even if jailed by foreign agents, Bukele is not a foreign agent, holding a citizen on our behalf, he's not. So he says, we're going to say you may be in custody under the color of law, under the authority of the United States. This is such a stretch, it's pathetic. Likewise, custody in violation of the Constitution or laws may also establish habeas. To be sure, actions of U.S. officials against non-citizens abroad will implicate federal rights only in exceptional circumstances, right? Including habeas only in exceptional circumstances. This judge is like crazy. He cites this 1950. He says, like, I know, like, I really can't do this. Like, this has to be absolutely exceptional. Boumediene versus Bush, Johnson versus Eisentrager. Two different Supreme Court cases says, you're going to go out and you're going to drape the great power of American citizenship and privilege over non-citizens in foreign affairs. What? You can't do that. There is little reason to think that Congress intended geographical coverage of habeas, the statute, to vary depending on the detainee's citizenship, citing another case. Now, he added the emphasis, okay? So this judge, again, is cherry-picking some law. He added the underline there and is shoving it in. He says, these people are resident aliens who assert that they have been removed from the United States under an illegal proclamation, denied any opportunity to challenge that removal, which is fake. I mean, they're in court challenging it right now. Many of them, by the way, never got moved, right? Like the JGG and these people. So yeah, there are people that were removed and the judge cited them at the top of this, but there were others that were not removed, okay? And they sued, they got notice, and they got opportunity to challenge it. They did challenge it and they were not deported. The others, this is all after the fact, okay? Sorry that you woke up in CCOT and you're like, dang it, I should have hired a lawyer real quick, shouldn't I? Man, I was sitting right next to you. That guy got one. That guy got one. Why didn't I do that? I just slept in that morning. Okay, that's your problem. The game's over. You don't get to come back and put points on the scoreboard. Transferred by U.S. authorities under a contract, right? This is the big question. He's going to say, is there a contract here? Those claims, if borne out, would show that they violated federal law and their due process rights because they're illegal gangbangers. They have more rights than you. In such a case, the government's use of a foreign intermediary would not alone necessarily defeat habeas, but or shield its actions from judicial scrutiny. We've already said you can't deal with, team up with foreign agents to undermine the constitutional rights of citizens in America, Judge. Rather, when the United States works through foreign officials to detain rights holders, Kilmar's not a rights holder. Federal habeas may be available. This judge is like really trying to make this fit. Now, given that habeas jurisdiction can lie when the detainees are in constructive custody, the question from the judge is, does jurisdiction, whether it does lie here? As indicated, they say, Trump is paying El Salvador millions, and we need to know whether that's true or not. So this opportunity to hold them, Trump has even stated, offered the United States the ability to outsource part of its system, right? So the judge is now going to Trump's statements and saying their support that maybe the detention in CCOT is being done by the United States. Now, some questions remain about the precise nature of this confinement. The judge writes, the court will accordingly authorize discovery. He's calling it jurisdictional discovery to somehow give him continued power over this case, even though the Supreme Court took it from him in their order that he's completely violating in multiple ways. Whether petitioners are in actual or constructive constructive custody, and the inquiry should include the following, right? So they can dig into this. Were these gangbangers detained at the behest of U.S. officials? Whether their ongoing detention is at the direction of the United States, whether they are being detained, and whether they have an opportunity to challenge their rights in the United States. And they want to give them now, like this judge is trying to create an opening, a path for them to create habeas filings from CCOT, right? That's like going to be extending his jurisdiction over the whole prison. So then everybody after the fact who had a bad deportation experience can now petition to get back into the United States. This man, this judge, is a terrible, terrible steward of the law, and much worse. Such discovery may very well implicate matters of the most delicate diplomacy, but he doesn't care. He's going to crap all over it. Courts frequently allow discovery into whether they can exercise jurisdiction, and so he has no jurisdiction. The Supreme Court already said so. You don't have it, but I'm going to allow discovery on it. And then he also issued contempt, held Trump in contempt, and said that he can use the contempt power to force compliance with his underlying order over which he has no jurisdiction. I don't know where Congress is on this, man, but they should wake up. They do so even in other situations involving potentially complex and sensitive discovery burdens on defendants. Courts have authorized discovery into whether a government official can claim qualified immunity. That's with immunity. Oh my gosh. Having concluded that they have made an adequate showing to justify further invasion, it will follow well-established practice. It's not well-established, Judge. You just said it. You just explained. All of this is done in exceptional cases, which is why you're doing it. As explained at the conclusion of yesterday's hearing, court therefore orders the following. By May 9th, Trump shall submit any declarations they wish to provide about whether the United States has constructive custody over CCOT, over all the deported gangbangers. By May 12th, the gangbangers shall submit to the court notice whether they wish to seek jurisdictional discovery. Of course they're going to. And if so, what do you want me to order you get? And by May 14th, respondents Trump shall submit any response to their discovery proposal. So Boasberg, one of the worst judges of all time, who is absolutely weaponizing his entire bench at this very moment. Supreme Court, its order was clear as day. This is a core habeas claim. Core habeas claims for these petitioners need to be brought in another location. He's finding manipulative ways to keep this case and to continue to turn the knife into the American people. And now, not only is he granting illegal alien Tren de Aragua gangbangers pseudo-anonymity, but he's also now allowing discovery to proceed so that basically everybody down there can file claims as well, right? And all of the class can be protected and, in Judge Boasberg's preference, brought back to the system. So we've got Tom Homan, who is responding to a lot of this, the Boasberg orders and more, saying that these sanctuary cities and the people who are facilitating this continual invasion or re-invasion of the country by the judiciary will be dealt with. Here was Tom Homan explaining.
You're over 100,000 now.
Yeah.
So you wanted to take the worst first. Have you gone through the worst?
No, we got a long ways to go.
Who else is left?
Well, when we started
this
this thing, it's just shy of 700,000 illegal aliens in this country with a criminal conviction or pending criminal charges. So we got a lot of work to do. I looked at the numbers the other day, just yesterday. ICE, interior enforcement arrests, are just below 75,000, which is 3 times more than Biden did in the same time frame when he was president. So ICE is making a lot of arrests, but there's more work to do. And actually, we had a series of meetings this past week. We're going to increase the number of the operation teams. We're going to increase worksite enforcement. Because of sanctuary cities policy, what we're going to do with sanctuary cities, we're going to flood the zone. If one agent can't arrest one bad guy in the jail and they choose to release him in the community, it means I can send a whole team to look for him. So in sanctuary cities, we're going to flood the zones with agents. If we can't take them in the jail like we should, the safety and security of a jail, then we'll go to the community and find them. And that takes a lot of people. So if we can't arrest them in the jail, we'll arrest them in the community. If we can't find them in the community, we'll arrest them at the work site. We're going to increase work site investigations too. Less agents in the jail means more agents in the communities, more agents in the work site. Let us in the jail. Let us arrest a public safety threat in the security and safety of a jail. Releasing a public safety threat back in the community, it's just foolish. It increases the threat of public safety. So we're going to do what we got to do to get these people off the street. I wish they let us in the jail. It'll be a lot easier, a lot more efficient, and a hell of a lot more safe.
Yeah, and we're looking forward to seeing some of the initial resistance start to come crumbling down. And this is a game of attrition, no doubt about it. And once the judges like Backdoor Dugan start to have repercussions coming their way and Congress grows a pair and stops people like Judge Boasberg, who have no jurisdiction by order of the Supreme Court, why are they not hammering that every single day from the Republican Party? They keep saying the Democrats are good at this. Trump's violating the Supreme Court to facilitate the return of Abrego. Every day like broken records. Where are the Republicans saying Judge Boasberg is in violation of the Supreme Court? He has no jurisdiction at all. He's ordering this stuff to happen. He should be impeached. They may not get it done completely, but they should bring the articles and get it through the House and make it hurt for him in terms of political consequences for for his unlawful and egregious behavior.